Good morning, everyone. I welcome you all to this Judicial Symposium on the role of judiciary in sustaining rule of law and democracy, comparative perspectives in India and USA. I would request Professor Dr. C. Rajkumar, Vice Chancellor, O.P. Jindal Global University, to open this Judicial Symposium with his welcome address.
A very good morning to all of you. A very good morning to all of you. It is indeed my proud privilege to welcome our very distinguished judges and also the Dean of the University of Hawaii Law School, who is also a distinguished jurist, to India and to O.P. Jindal Global University. We have been planning for this event initiative for a very long time, and I'm so delighted that this has come to fruition. So let me take this opportunity to extend a warm welcome. I'm so delighted that several of you as students of Jindal Global Law School who are present here. Let me begin by saying that this concept of a judicial symposium is so critical for the times that we are living today. Increasingly, we are noticing that democracies are facing different forms of threats, both within and from outside. And in that changed world that we are living, it's absolutely important for us to recognize the role of a number of democratic institutions which have a very pivotal role in ensuring the need for protecting the rule of law and to engage in the larger objective of promoting access to justice. Judiciary is one such institution. And so the first objective of organizing this symposium here at Jindal is to advance that. The second is also to recognize that how in an increasingly complex world that we are living, which has barely recovered from a global pandemic, the interdependence of us as countries, as nations, as societies, as institutions, the opportunity to bring 10 outstanding jurists from the United States to India and to have them engage with all of us and here in India is also an opportunity for us to understand each other better. It's also important for us to recognize the role of vibrant constitutional democracies such as India and the United States in advancing the cause of the rule of law. The third objective is a more specific objective towards engaging with young people. I was telling my American friends that India is a country of 1.45 billion people, and today we have become the world's largest country as in terms of population. But we are also something that we don't adequately recognize is that we are also one of the youngest countries in the world. 950 million people in India are less than 35 years of age. At the dawn of Indian independence in 1947, our life expectancy was 32, and today it is 72. That essentially means that Indians are living longer. And I believe in the next decade, it will move up to 80. Which also means that when most of the Western world will become older, when most of the Eastern world, including China and Japan, will become older, India will be younger and will be younger for a longer time. Young Indians, like all of you, will be shaping the future of India and the future of the world. That also brings huge responsibility when it comes to shaping the notions of the rule of law and also to build yourself capacities to address the big issues of our time. Our goal through this symposium is to inspire you and to be engaged with the larger objective of protecting the rule of law and sustaining our democratic institutions. The fourth objective of this vision or this initiative is also for our judges, friends from the United States, to get an understanding of India's complex legal system, India's democracy, India's diversity, India's pluralism, and our deep commitment towards strengthening those values of democracy and constitutionalism. In 1947, when we got independence, India had a choice to make, which is to basically decide that, you know what, since 80% of our population are illiterate, might as well give the right to vote only to people who were educated, who were rich, who had resources, who had quote-unquote intelligent. But India made a huge decision at that time, and the framers of our constitution were very conscious of the fact that we decided to do what is considered then and clearly even now one of the most radical experiments of democracy, which is to provide for universal adult franchise, which essentially meant that everybody who was above a certain age were given the right to vote, regardless of their economic status, their caste status, their religious status, their income status, their education status. And that decision, the single most important decision that was taken, essentially resulted in creating a collective consciousness of democracy, and we never looked back since then. As we celebrate the 75th year of Indian independence and our evolution as a democracy, we are indeed facing new challenges. The challenges of democracy also comes with other forms of challenges, including poverty and inequality, discrimination of different kinds, issues that we have to address both at caste and religion and at societal level, issues surrounding to what extent our education system can step up to the aspirations of young people, to what extent employment can be provided for educated people so that they can engage in themselves meaningfully for their future, to what extent we can build safe societies, to what extent we can address the institutionalized forms of inequalities, especially through gender, and to what extent we can empower women so that they can play an equal part in our society. These are issues that we are confronting as we speak. And the most important part of that effort is also about the role of judiciary. Now, another remarkable thing that we did in 1947 was that we chose to adopt a parliamentary form of democracy, but one of the things that we did was we decided not to make any particular wing of the government as supreme. As we borrowed our Westminster model from the United Kingdom, it was quite obvious that we could have gone in that route and say that the parliament as an institution is supreme, but we didn't. We could have just gone ahead and said that we will follow the British model and ended up making parliament as a supreme institution. But we decided not to do that, and hence we have a complex constitutional structure in which all forms of the different wings of the government, the legislature, the executive and judiciary, are operating in its own wings and its own powers as part of the separation of powers. But who decides when one of the wings of the government is not acting in accordance with the constitutional framework? And that power ended up being vested with the judiciary. And hence, our judiciary, the Indian judiciary, is among the most independent, autonomous institutions that the world has seen, but also a very powerful judiciary, and its evolution and growth in relation to its own juxtaposition in the constitutional scheme of things is quite remarkable. It began as a very relatively conservative court in 1947, but if you look at the evolution of the court, it has become one of the most progressive courts in the world. In its early origins, it had amazing judges such as Justice B.R. Krishna Iyer, Justice Chinnappa Reddy, Justice P.N. Bhagwati. All of them were ready to expand the rights framework. In fact, Justice Krishna Iyer was very close to Justice Douglas from the American Supreme Court. They were hugely influential in their thought process. But at the time of the constitution-making process itself, India and US had very strong ties. In fact, the advisor to the Constituent Assembly, Dr. B.N. Rao, specifically went to United States and he consulted with Felix Frankfurter. And Justice Frankfurter advised Mr. Dr. Rao about, the Constituent Assembly was debating whether in the Constitution we should be using the word due process clause or another clause. And Justice Frankfurter strongly discouraged India to adopt the due process clause, and hence we decided to go with another clause called the procedure established by law in Article 21 of the Constitution. But it's another matter that several decades later, in a landmark judgment by the Supreme Court of India in Menaka Gandhi versus Union of India, we decided to essentially change that model, and through judicial creative interpretation, our current position in law, which has been for the last several decades, is that we have ended up adopting the due process clause read into our Constitution, going against the advice of Justice Felix Frankfurter as well as Dr. Rao when he advised the Constitutional Assembly. Now, these important landmarks, as I outlined briefly, is to tell you the extraordinary learnings that we can have through understanding of comparative law, through looking at judgments and interpretations by different courts. India has had a very progressive Supreme Court and High Courts where we constantly draw upon jurisprudence from other parts of the world, including United States, UK, European Union, and of course more recently South Africa and other parts of the world. And that aspiration to be able to look at other experiences from other parts of the world is part of the judicial journeys and interpretations our Constitution has. So I want to end by saying that for all the students who are present here, it's an absolute treat. These 9 judges and 1 distinguished academic who are here with us are truly outstanding. They represent different courts of United States. They also represent different approaches to jurisprudence. They straddle across different worlds of jurisprudence, from public law, private law, commercial law, corporate law, environmental law, dispute resolution, and numerous other areas as well. But what singularly unites them as a part of a collective imagination is their deep commitment to the rule of law, deep commitment to notions of justice, deep commitment to law, and recognizing that law is an instrument of social change and social engineering. And they have taken extraordinary efforts to travel from long distances to be in India. It's barely 48 hours since they have been in India, and they have been engaging and interacting with judges, lawyers, law academics, and others in the last, since they came in. And this is, of course, for many of them, the first trip to India. But of course, they are led by an amazing friend of India and of our university, Honorable Mr. Justice Michael Wilson. And at this point of time, I'm going to invite Justice Michael Wilson, former judge, Supreme Court of India, and honorary adjunct professor, Jindal Global Law School, to share his perspectives. Thank you very much.
Aloha, everybody. I should say aloha and namaste. Aloha means pretty much the same thing as namaste. You recognize the beauty and the human spirit that we all share. And I'll apologize for my enthusiasm today because I'm home. I think of Jindal as not just a home and a place to go because you have these magnificent graphics that make us feel so important with these beautiful pictures, but also because of you. And I say that because I don't have any question that at some point in the 5 or 6 years that myself and my beloved colleagues, Sabrina McKenna and Todd Edens, have been coming here, we're addressing some members of the future Supreme Court of India. And how many of you have heard of Ashoka? Raise your hand. Aha, descendants of an amazing man, right? 2,000 years ago, he came up with the rule of law, freedom of speech, protection of animals, application of the laws in a way that was meant to be equal. And I don't need to speak to you much about the father of your country, Mahatma Gandhi, but do you represent that? Absolutely, that is what Jindal's about. Anyway, how many people have heard the motto, anyway, at Jindal? Okay? Familiarize yourself with it because it means do the right thing anyways. And doing the right thing might have something to do with the rule of law and democracy, particularly if who participates in a way that's fair. Who needs to participate in a way that's fair for there to be a healthy democracy that you can have confidence in, that will allow you to think that your future is going to be one that's protected in terms of your rights? Judges. Today is one of the great days, I think, for all of us and certainly for me, but you don't know all the judges yet. The judges that are here are icons. They represent the power of the rule of law, which is greater by far than any nuclear device. The power of the rule of law used how? When you, and some of you will become a judge, you'll be able to decide, do I use it so that I can have power? Do I use it to achieve justice? So it's great to be in the presence of judges that are practiced and proven when it comes to doing the right thing. The other thing that's so exciting is, how many of you are younger than 40? Raise your hand. That is so cool, because if I ask you, what is the most important issue in your democracy, in your government, in your world, in your studies that decides your future? How many of you would say climate change? Right. Well, we'll talk a little about that. So it's a nice way to be able to address the idea of the rule of law, judges, and democracy, to consider an issue that's really important to you. And this is my very last slide. So let's see if we can go to the first one too. And so I come from a state, Hawaii, that has benefited from being with the justices of the Supreme Court of India who've come to visit us. We have also had the benefit of being with your Vice Chancellor, Vice Chancellor Kumar, who is certainly an avatar of justice. And why do I mention Hawaii? Because okay, let's see what we got here. The most remote landmass on Earth. Maybe the ideal environment in the minds of the collective human consciousness. It sits out in the middle of the ocean. It is magnificent. And today, the one thing you'll probably remember the most that I say, you're all invited to my beach house. It's a beautiful place. The Vice Chancellor, I try to get him there whenever I can. You know, he works too hard and doesn't usually get a chance to come. Oh my goodness. This is the main reason I wanted to use slides, right? So you can get a sense of the beauty, the natural beauty, the power. How many of you have a place in your heart that is so extraordinarily beautiful that it's become part of you? That's what happens when you come to Hawaii. It is such a powerhouse of nature and God, it's almost overwhelming. These are our treasures. These are the treasures that have to do with the application of the rule of law and democracy in Hawaii, because we are facing an emergency that's like no other emergency. Secretary General of the United States, Secretary General of the United Nations says what about climate change and the nature of the emergency? It's the ultimate. There's never been anything like it. Take the pandemic. Was that serious? We can all agree it was serious. Did people die? We can all agree that it died. But when it comes to humanity's future, the Secretary General says the pandemic pales in comparison to the greatest threat to humanity that we're facing, which is climate change. And does climate change affect everybody the same? You are affected by it more than I am, because I'm 70. That's the reason I had to retire. You're going to face what's coming in the next 30 or 40 years. And when I say you're the face of India, you're the face of Ashoka, you're the face of Mahatma Gandhi, you're the face of a future that hopefully will help us. That's why I'm here from Hawaii. We have 1.4 million people. Do you know how many lawyers you have? I mean, there's 5,000 lawyers at Jindal Law School. You have 1.4 million lawyers, the same population as Hawaii. So you will make a difference to us in the way you handle this issue. Why is that important? We are on the front line and being devastated. How many of you have heard about the fire in Lahaina that happened in Maui? Right. It's international news. And you probably care about Hawaii, right? Because you're my brothers and sisters. India is our brothers and sisters. We're very similar. We have diversity. And we have a lot of trouble with a thing that we love, which is the environment and the tradition of India. The reason you have tigers, the reason you still have magnificent beauty is because you have a culture, you have a religion that's committed to it. So what happened in Lahaina? 100 people burned to death. That sounds like a lot. It's not anything compared to the number of children that are going to die in India when the Earth's heating up to 1.5 degrees, if it does. I was just meeting with the final stand. Raise your hand if you're with the final stand. There you go. A powerful group raised in Jindal, created in Jindal, that decided we are making the final stand. We are not going to let India go down the tubes. We're going to do everything we can to keep the Earth from heating up to 1.5 degrees. Judges. What is the role of judges? To pay attention to the truth. Pay attention to the facts. Pay attention to the fact that the Earth can't heat up to 1.5 degrees. Pay attention to the laws that really are important to your generation in the future. In Hawaii, our legislature has said we are in a state of climate emergency. So we'll lose this beach. That's Waikiki. Secretary General of the United States has a way, of the United Nations has a way of describing this over and over again. He says, we are on a highway to climate hell with our foot still on the accelerator. We, what does that mean? You are more in the car than people that are older than 40 years old. So we're on track to go to 3 degrees, and we have to prevent that from happening because the rule of law is likely to disintegrate along with the heating of the planet when we get to 1.5 degrees. The law is so powerful. This is a group of words that has spread all over the world, written by a judge in the United States. The most important case I would submit in the United States, certainly to you and our future generations. Exercising my reasoned judgment, I have no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. How many of you think that makes sense, that your generation has a right to a life-sustaining climate? Raise your hand. Thank you. And how many, raise your hand if you're going to be on the Supreme Court of India. You don't really have to. Oh, I like that. We have some hands go up. Beautiful. Please let me know. I want to be there when you're sworn in. But the courts in the United States aren't there yet. They have been too deferential in the arena of environmental law, and the world has suffered for it. That's the language of a federal judge. This is what's happening. Students are getting organized. They're going to the courts. And some of the judges are focused in a way that would suggest they're attending to your what? Climate anxiety. If you think about what's going to be happening in the future when, say, 40 years, over 100 million people leave Bangladesh and start heading to India because of sea level rise, when your glaciers are melting, and when, more importantly, you have more and more children that are dying because, like the people on Lanai that were burned to death, they burn to death because the temperatures are too hot once they get to above 1.5 degrees. So this is a dissent of a federal judge at a different level, a higher level in the courts of the United States. In these proceedings, the government accepts as fact that the United States has reached a tipping point, crying out for a concerted response, yet pressed ahead toward calamity. So the majority decided to take a position that did not recognize your rights, did not recognize you have a right to a stable climate, but this dissent disagreed. It said, it's as if an asteroid were barreling toward Earth, and the government decided to shut down our only defenses. Now, if you were having this discussion in a class, it would be important. Ideas are so powerful, but imagine if your idea was supercharged because you were a federal judge. This judge has the power to stop the subsidies of the United States. We subsidize fossil fuel. Fossil fuel industry made record profits after the pandemic, over $200 billion, received $1 trillion in subsidies from international sources. So this idea that a judge would have the power to shut down subsidies, for example, makes the point about why these words are so important and why I hope you do become judges. Seeking to quash this suit, the government bluntly insists, the government of the United States bluntly insists that it has the absolute and unreviewable power to destroy the nation. So you can see why the rule of law is so important, and the participation of people that are focused on, you could say, the democracy. How healthy is the democracy going to be? What kind of rights are you going to have as a parent? What kind of rights are you going to have as a citizen when you really don't have a healthy environment? You have an environment that means you might not have even a world economy that is hanging together. So, another Supreme Court justice in the dissent saying the same thing, that the courts, the federal courts, have to wake up to their obligations to regulate greenhouse gas emissions. In the state of Hawaii, probably doesn't surprise you, one of my beloved colleagues who I referred to earlier, Justice Edens, wrote the most powerful climate case in the United States and found that in the state of Hawaii, you do have a stable climate, you have a right to a stable climate capable of supporting human life. So maybe remember this. This is a tool for you as you go along. These are 3 cases that say you have a right. But you have a court that's one of the most independent, inspiring of any court in the United States. Your judges are famous for being independent in your Supreme Court, and they have really helped us. And they've helped you. This is you. This is the government and the special interests that want to continue to increase the burning of fossil fuels. Okay. We're up against the odds, but we can prevail with the final stand and with India. Now, this is, in conclusion, worth pointing out. This little skinny lawyer, who really, when he would speak, wasn't all that, charismatic. Look what he did. His idea. He represented India, though. He represented Ashoka. He inspired one of our great civil rights leaders, who was assassinated. Who do you think that was? Martin Luther King. That, he made the point. He believed a small body of determined spirits fired by an unquenchable faith in their mission can alter the course of history. We have 8 of them sitting in the corner up there. And I would submit there are a bunch in this audience too that are going to make sure that as unquenchable spirits fired with faith, we make sure that this group is taken care of. These are the true, shall we say, vulnerable, poor, and it turns out young people, children. Where are they? Most of them are in India. So there are individuals that have given their lives. There are justices that have stepped forward. This is a famous justice from Colombia that went to Colombia to try to help the village where a famous environmental defender was killed. This is an extraordinary judge who's already shown his independence and helped inspire us in Hawaii. There they are. This is Hawaii with your justices and our justices. And here's the final stand in the office of one of my true living heroes. This is a collaboration between the University of Hawaii Law School and Jindal Law School. This is my favorite animal on earth. Whenever I have a slide, I try to show that, and Vice Chancellor helped me find it. Took a long time. But if you can have tigers, it shows that you have a way of protecting your environment that's extraordinary with a civilization 2,000 years old. And there he is, the avatar of justice in my office. And he's a little bit like Gandhi. He's not skinny. You may have noticed. And when he speaks, he's more charismatic. But we wouldn't all be here if it wasn't for him. This whole place wouldn't be here, and Hawaii wouldn't have been inspired by the Supreme Court of India if it wasn't for him. Okay, so I finally get to say aloha. It is, as you can tell, an incredible privilege to be with you. I wish you all the best. Make sure you let me know if you want to go to the beach house, but more importantly, make sure and let me know if you get sworn in to be a Justice of the Supreme Court of India. Aloha and namaste.
Thank you, Justice Wilson, for those powerful words. I would like to request Professor Sridhar Patnaik to present the vote of thanks.
Thank you so much. Justice Wilson, as always, a pleasure listening to you. It's very inspiring and very encouraging. All the dear students and distinguished guests from the United States, good morning, everyone. I would like to join my Vice Chancellor and add one particular point in telling you how historic this particular movement is, because in the past we had professors and researchers visiting us and engaging with students and faculty, be it at the Gender Global University or other schools and universities within the country. But this is indeed historic and momentous because we have a galaxy of judges from the United States visiting us, and to my limited knowledge, it never happened before. At the beginning of this year, there were few judges who were part of a delegation, but that's for a different purpose. So here you have an opportunity to engage on the issues pertaining to comparative law and comparative public law. You might allude to any number of written sources, but the living sources are altogether different, and you will get to know more about the intersection of rule of law, democracy, and constitutionalism this afternoon. So I appeal to each one of you to make the best out of this session and the subsequent sessions you have this morning for your benefit. I am grateful to the Vice Chancellor indeed for having curated this wonderful movement for all of us. I would also like to thank the judges and the Dean of the William Richardson School of Law, University of Hawaii, for their presence. My gratitude goes to Honorable Mr. Justice Michael Wilson, former judge, Supreme Court of Hawaii, a dear friend and guide to the General Global Law School, for his time and efforts in collaborating with us. We are grateful to Honorable Ms. Justice Sabrina S. McKenna, Judge, Supreme Court of Hawaii, for her continued collaboration with the General Global Law School and the university. We are thankful to Honorable Mr. Justice Todd Edins, Judge, Supreme Court of Hawaii, for his presence here and for his continued work with us. And we are also grateful to Honorable Ms. Justice Ann Aiken, Chief Judge, U.S. District Court, District of Oregon, for her presence. We are thankful to Honorable Ms. Justice Jenny Riviera, Associate Judge, New York, the State Court of Appeals, for her presence here this morning. We are thankful to Honorable Ms. Justice Sarah L. Ellis, Judge, the United States District Court, Northern District of Illinois. We are thankful to Honorable Ms. Justice Josephine Staten, the Judge, U.S. District Court, Central District of California. We are grateful to Honorable Mr. Justice Douglas Tukey, Judge, Oregon Court of Appeals, followed by Honorable Mr. Justice Andre Birot Jr., Judge, U.S. District Court, Central District of California, and Dean Camille Nelson, the Dean of the William S. Richardson School of Law, University of Hawaii. So before I conclude, I would like to congratulate each one of you for this wonderful movement. It is historic, and you're part of this historic movement, so please make the most of this particular panel discussions that you're going to have this morning. Thank you so much.
We now open the Judicial Symposium. We'll move towards the panel discussion on the role of judiciary in sustaining rule of law and democracy. We'll have Dr. Popovsky as the moderator, and I'd like to request everyone to please join us on the stage.
Due to paucity of time, what we've done is instead of 3 separate thematic sessions, we have combined it to one session where all our 8 judges and our academic will be there. Mike, you sit down. Yeah, we are together downstairs. So, and they will have each, as our moderator mentioned, 5 to 7 minutes, and then we'll have a longer Q&A session. So now I invite Professor Dr. Veserin Popovsky, Professor and Vice Dean of Jindal Global Law School, to take forward the proceedings. The goal is to do at least 1 hour of their presentations and then 45 minutes of a Q&A session. Thank you.
Well, good morning, everyone, and allow me also to welcome our distinguished panel. Actually, I've moderated many panels in my life, and it is really historic, as the registrar said. I never had in my long career 9 justices and a distinguished professor, dean of the Richardson School of Law in Hawaii. And it is really an opportunity for all of you. I invite you to listen carefully to the initial 5 to 7 minutes presentations and to ask as many questions as you may have. We'll have plenty of time. That's why we combined the 3 sessions. It will be one longer session, and you can ask questions to this really distinguished panel. Let me briefly just say one thing. Mike mentioned Ashoka. I want to go even further into the history and mention something from where I'm coming from the Balkans. There was the first mentioning of the rule of law. Apparently, it's Greek legends. You know, Greeks always claim to be first on everything, but probably on this one, they might be said to be the first one. There was a battle between the Spartans and the Persians. And before the battle, the king of Persia, Xerxes, was telling the king of Sparta, my soldiers will defeat you because they trust in me, they respect me as the king, and they will die for me as a king. The Spartan king replies to that and say, no, 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 my soldiers will defeat you exactly for the opposite reason. Well, they might respect me, but they respect more the law. They are free citizens. And because they respect the law, and not so only me, they will defeat you. So that's early mentioning of the importance of the law above the king, above the man. Remember this lex, rex, and rex, lex, law above the king. And we see this very often in the history of the legal literature. We remember the famous formula, not law of man, government of law, not government of men, which is again associated with Aristotle, another Greek philosopher, to the current day, to 2023, when we have the excellent topic of the discussion today, the role of judiciary in sustaining rule of law and democracy. So my big pleasure, my honor to have all these distinguished justices from various parts of the United States, and to invite first Justice Sabrina McKenna, Supreme Court of Hawaii. 5 to 7 minutes, please.
Thank you. Aloha and namaste. My name is Sabrina Shizue McKenna, and I am here speaking first to try to provide a definition of the rule of law and how that impacts the judiciary. Before I do so, I think I'd like to briefly explain, because you may be wondering where we're all from and the court structure. In the United States, we have a federal judiciary, and each state also has its own judiciary. So some of us are from the state courts, and in the United States, each state, in addition to the United States government, each state has its own constitution. So state courts, state high courts, are free to interpret their constitutions to provide greater individual rights or greater rights under the state constitutions. And that's why Justice Wilson was talking about our environmental law decisions regarding the right to a life-sustaining climate. And the other thing I will mention is each state has different names for its state courts. So Jenny Rivera Court of Appeal is actually the highest court in New York. So it would be equivalent to the New York Supreme Court. So I thought I would just mention that. I also want to mention that in the United States, of course, as in India, judges are selected or elected from practicing lawyers and or prosecutors. I myself grew up in Japan and went to the University of Hawaii Law School. I was a civil litigator, law professor, and then corporate counsel before I became a limited jurisdiction trial court judge. I was a trial judge for 17 years, and then I joined this court in 2011. But now I want to talk to you about the rule of law and what it means. I encourage you to look up the World Justice Project. It is a very respected organization with many prominent legal leaders from around the world. And if you go to their website, they define 4 principles of the rule of law. The first principle is accountability, that the law, government, as well as private actors must be accountable under the law. We have cases like this, some important cases happening in the United States. The second principle is the fact that the laws must be just. The law must be clear, publicized, stable, and applied evenly. It ensures human rights as well as property, contract, and procedural rights. The third principle is open government. The processes by which the law is adopted, administered, adjudicated, enforced are accessible, fair, and efficient. But it is the fourth principle that I want to talk about, which is relevant to all of us, and especially, I believe, in India. The fourth principle is accessible and impartial justice. Justice is delivered timely by competent, ethical, and independent representatives and neutrals, judges, who are accessible, have adequate resources, and reflect the makeup of the communities they serve. Judges must reflect the makeup of the communities they serve. In other words, judicial diversity, the fact that judges need to reflect the makeup of the communities they serve as a principle of the rule of law, means that the diversity in the judiciary is not an aspirational goal. It is a requirement of the rule of law. And why does this matter? Public trust in the courts. People tend to trust courts more if the people that are making the decisions look like them and come from their own backgrounds. And why else is it important? It instills richer jurisprudence. Different ideas come out when you have diverse judges. I can tell you that it makes a difference. I'm on a court of 5. It makes a difference when you have people of different backgrounds. It enriches deliberations, and it establishes role models and combats stereotypes. So it is really important, and it is a requirement of the rule of law that we have a diverse judiciary. In the United States, we are not in full compliance. We have about 38% of our lawyers now are women, about 1/3, and it depends, the federal and the state, depending on the state. Different jurisdictions have more diverse judiciaries. Hawaii, the state of Hawaii happens to have the most diverse judiciary in the country. And unfortunately, in the United States, their white men are overrepresented in the judiciary. But in a sense, we are doing much better than India. This is something that I have been talking about. Every time I come to India, I talk about why are there so few women in the India Supreme Court. You only have 3 out of 32 now. And this is why I'm telling you that judicial diversity is a requirement of the rule of law, so that you young law students can start talking about this as a requirement of the rule of law, not something that they should be striving for. You can tell your government that they are not in compliance with the rule of law because they lack diversity in the judiciary. And that is really important, okay? So please start talking about erase that as an issue. And it's a little, and I understand there's a lot more discussion about that now. You have a lot about talk about how the Supreme Court is overrepresented in terms of social economic class as well. And we're not perfect. The United States Supreme Court is definitely not perfect. But I really encourage you to start talking about judicial diversity as a requirement of the rule of law. And I also want to mention that I am the first open member of the LGBTQ community of an Asia Pacific American background to serve on a state court of last resort. And we have at least one additional member, Judge Tukey, from the LGBTQ community. We can be open and talk about this. And you had a nominee, a gay, openly gay, senior advocate nominated to Delhi High Court, and the government will not improve him. And I am a board member of the International Association of LGBTQ Judges, and I don't think we have one member from India. We have members from all Commonwealth countries, but not from India. So I encourage you to advocate for diversity in your judiciary. It makes a difference. Thank you.
Thank you very much, Honorable Justice Sabrina McKenna, for emphasizing the importance of diversity among many other elements, and the definitional idea that the will of people need to be really represented in the justice, to be just, to be equal, to be accessible, but also, as you pointed, marvelously diverse. Next in our list is Honorable Justice Ann Aiken, the Chief Justice of the U.S. District of Oregon. Please, you have your time.
Good morning. I am having a flashback as I look across this room, and I remember vividly sitting probably where that gentleman is in a red shirt, red and black shirt, in a classroom, and for the first time heard a speaker who was teaching constitutional law, his portfolio, American government, the executive branch, the presidency, Supreme Court. He taught the array of classes, and I was a pre-med student, and I happened to take that class as an elective, and it changed my life. It changed my life because it didn't matter as a physician, I still that work, the science of all of it matters to me, but to help one person at a time or to be part of government, the law, and changing it for everyone seemed to have a greater calling. And a faculty member standing at a podium like this changed my life because they taught us that we could dream big. It is overwhelming to be standing here today because I answered an email from former Justice Michael Wilson. I didn't know him. He wrote me an email after I wrote an opinion. And he started a dialogue with me for a long period of time, and he would send me information, talk to me about would I come and do this, would I come and do that. And I was like, I just do my work, and I have a family. I've had 5 boys, I have grandchildren, I have a busy, and I thought, this person keeps emailing me, what could this be? But you don't know today what person, what judge on this panel might change your life. These are extraordinary judges. I'm just in awe riding on a bus talking to them. It's a privilege to be with them, but it is beyond my imagination to be with a gifted visionary, a gifted individual who has invested in education and children in India and has built this magnificent university. I could not stop taking a video and talk about what a difference you all will make just by what you've done by reaching for excellence, not be willing to settle, to stand up and care, to make a difference for your community. I am here to be re-inspired in my work and to be here and to understand how powerful together we can make a difference. So I want to go back to something really simple that I'm going to play on what my beloved, my new best friend, Professor Kumar stated. We are so united, I don't think people understand. There's a wonderful book, if you have a chance to read it, called Caste, written by Isabel Wilkins. And what I think is the most powerful part of that book, and what moved me to move into law and to change, was the discussion when Martin Luther King became so discouraged by what was happening in the United States and how racism was destroying people, poverty was destroying people, and the Vietnam War was destroying people. He came to India. He came to India. And his first introduction was as follows. It is our honor to introduce Martin Luther King, the leader of the lowest caste in the United States. He was horribly offended. He was angry, he was upset, he was shocked, and he had a very hard time sort of processing the information until he stopped and thought about it. And he said, it's true. It's true, we just don't call things by those names, but that's true. And it re-inspired Martin Luther King to return to the United States and re-engage in the civil rights battle. Now, I was in college, not even really college, probably I'm a junior year in high school when he was assassinated. It changed my life. The assassination of Bobby Kennedy and John Kennedy changed our lives because our country was being run by individuals, not by the rule of law. People with a gun, not allowing people to vote, not allowing people to have access to jobs, to education, to opportunities. So it became very clear to me if you could do work on behalf of the individual or you could do work on the behalf of the community. And that was the day I sort of decided that I had to work on behalf of the community and find a way to participate. And the only way from there to here was through education. So what this university means to all of us and the rule of law is to educate you all as the next generation of leaders to understand that you have an obligation to be stewards for the generation that comes after you. Just as you look at all the documents that have been posted, we have an obligation on the bench to remember that we are stewards for the next generation of people's lives, our grandchildren, our community's children, everyone. And so when we approach these cases, you have to look at them stepping back and understanding what's under the rule of law. How do we make our decisions, and how do we look in a mirror? How do we look in a mirror that we made the right decisions and that we honor the rule of law? And it's not about men, it's about the rule of law. So, but I have to go back. I do this, they're obviously not enough. I give away the Constitution. My children carry them. I carry one in my purse always. You can get stopped at any point and you pull the Constitution out. In our country, this is gold. So I give it away at naturalization ceremonies. I give it away at every event I speak at. I take the Constitution everywhere. This document matters, and you can make so much, so there's so much power in understanding what these words mean and how to interpret these words in a living document. But it really goes back to what I want to say about the connection between India and the United States. Dr. King came back and stood up for the rule of law, the opportunity that your vote is no better than the next person. Everybody's entitled to vote. Everybody's obligated to vote in a democracy, and we have to preserve and protect that. And we fight those issues today. And as judges, it's our obligation to make sure that everybody's votes count, that everybody has the opportunity to vote, and that we step up so that it is across the board a democracy that's fully participatory. India is ahead of us. Your voting rates are much higher, and your opportunity to participate is seen more of as a privilege. In our country, we have to fight to make sure people get out there and vote because people are discouraged by democracy. But I am re-inspired by what democracy is doing over here and what changes you are making as a result of having the incredible visionary leadership and power and resources to make a difference because the investment is in children. But I want to close because something I hope you will ask me about, because the bottom line of what I care about on the bench. I love my job. It's amazing. But my free time is spent with this organization. It is an organization that is now almost 40 years old. It's early intervention for children of abuse and neglect and families that are struggling. It is a nonprofit. It is holistic. It is evidence-based. It is our opportunity to take children across the board and give them a fair shot at life and a fair shot at participating. And we have nurseries, they're therapeutic classrooms. They're an opportunity so that we do not fill our prisons with people who did not have an opportunity or an education, and all they knew was to go out and commit crimes because they did not have an education. These are, I think, one of the most important ways in which a community, a country can invest in the future, and that is from 0 to 6. When the brain is forming, we can make a difference. And one of the things I care about and talk a lot about is trauma-informed care and what trauma does when children are abused and neglected and not given the support and the brain development appropriately. We are setting ourselves up for failure down the road. So what I have found most satisfying, in addition to the work that I do, is I've served on the board of this nonprofit for close to 35 years. And so every day in the courtroom, you're dealing with very difficult people who've had, oftentimes in the criminal setting, no opportunity for success. So the way to combat that and to be a part of it is to work on solutions. So I brought some brochures, and if anybody's interested in talking about it, this work, I love my job. I love the opportunity to be a part of the judiciary. But you know what? If you change a child's life, if you change the trajectory of a human being's life and opportunity, there's no greater gift. So the rule of law has given me the opportunity to look broadly at these issues, and on the bench to take a look and to write differently about what the solution should be to the problems. And so the judges that are seated here, do not underestimate the talents of each one of them. Todd Eddings down there, what he wrote for Hawaii, the climate change case for Hawaii, I bow down to him. Joe Stanton, who sat and wrote an incredible dissent on the Ninth Circuit, leadership beyond all measures, all measures. Andre Barat, former US attorney, now on the bench, taking a look at broad issues in LA, unbelievable. Sarah Ellis in Chicago has run a reentry court, difficult city, difficult problems. She is just a master in that domain. Doug Tukey, one of the leading lights, former legislative council member, drafter, brilliant, lived and worked across the world. Sabrina, one of my heroes, just I bow down, what a privilege to be on the panel with her. And then in many respects, our beloved leader down there, the Dean of the Law School of Hawaii, who's beyond an innovator, beyond a caring person, and beyond somebody that you all should figure out how to know. So we're going to talk about the rule of law, and it'll be formal, but we're here as people. I'm here to make connections because one of you might write me an email, and I might respond, and you never know where that's going to go, because I just answered an email, and I'm here today because I just answered an email. Okay, so it's all personal. It's all about people. So please treat us that way and come talk to us. Don't treat us as anything other than we are just older versions of you. All right, thank you.
Oh, so wonderful. Thank you so much, Honorable Justice Ann Aiken, for making this very personal speech and also very human, somehow telling us and reminding us that the law is really human. It goes to every single house, to every single child. And also thank you for the excellent work you are doing. And thank you for bringing those gifts to us. And the idea that nursery relief needs to be taken care of also as part of the, so in a way the rule of law is not somewhere in a kind of a supreme court exercise. It's in everyday life of every single organization. Really amazing. So from Oregon, we move down to California with Justice Andre Birot Jr. Honorable Justice Birot comes from District Court of California. Please, your time.
Thank you, sir. Well, good morning, everyone. It is an honor to be able to spend some time with you, and I'm going to try to be very brief, but I want to take a little bit and follow up on what you just heard from Judge Aiken. Obviously, we all here feel very strongly about the role of the judiciary and instilling our democracies in our respective homelands. But I think Judge Aiken said something that I think is also vitally important, that it is all about human beings. And it's important to remember that. I had served as a public defender and then a federal prosecutor, and then I ultimately ended up leading the office from 2010 to the time that I became a judicial officer. And it was at that time that I was able to take the opportunity to look at and try to figure out alternative ways to deal with some of the challenges and issues that come up in criminal cases. And through great work with the Public Defender's Office, the Probation Office, the U.S. Attorney's Office, we came up with a program called the Conviction and Sentencing Alternative Program, affectionately known as CASA, because we felt that it was a way to bring people to a different home. And through that, we started to look at individuals' backgrounds and circumstances that brought them into the criminal justice system and tried to address some of those challenges. You would be surprised. Many of us take for granted the fact that we, are able to have a bank account or know the foundations of fundamental eating principles, how to coexist in the world. But when you find out, when people that are exposed to trauma at young ages, those things are not necessarily the case. And through this program, we take individuals who have been charged with crime and try to address some of the issues that brought them here in the first instance, whether it's substance abuse disorder, alcoholism, family trauma, and we work collaboratively with a team of social services experts, probation officers, defense lawyers, prosecutors, to help give them the tools to try to move forward in their lives, to try and hopefully give them the tools so they don't come back to court as a defendant in a criminal case. The statistics are quite alarming about what's known as the recidivism rate in criminal cases, where individuals, once they get in the system, many times because we warehouse them in some instances in the United States, and they just go into the warehouse and they get released, no better skills or tools to address what brought them there in the first instance, and then they come back. And so we hope that in doing a program like this, it gives them some tools. And the program culminates in a graduation where the participants speak to the larger group about what they learned, and you'd be surprised. People who celebrate things that we take for granted, having a bank account, being sober for the first time in their lives, many since they were children, maintaining productive relationships with their family members or in the work environment, learning how to eat basic 3 meals a day. We had one CASA participant who was a mother of a child, and her dining regimen consisted of whatever was being sold on sale at the local bodega. And that could mean tacos, Doritos, hot dogs, hamburgers, and this is for an infant. She had no background or experience, and through this program, we gave her the tools that she could learn about these foundational things. And although this may not apply, but I'm going to ask this question. How many of you have ever heard of the movie Willy Wonka and the Chocolate Factory? Okay, well, that's great. So every time I meet someone in the CASA program, I tell them, congratulations, you've just been given the golden ticket. And for all of you that know the movie, you get this golden ticket and you go through some trials and tribulations. But if you work hard, stay focused, you can change your trajectory of your life. And this CASA graduation is something that I think helps changes a lot of people's lives. And we've had an extraordinary success in our CASA program. We had one individual in particular who ultimately graduated from the CASA program having been charged with bank fraud as a bank teller, substance abuse, some trauma as a child, successfully completed the CASA program, went on to graduate from college, then law school, and now is a practicing lawyer in Los Angeles. But for that program, I shouldn't say but it is likely, had he not been given that opportunity, he would have sustained a felony conviction, It would have challenged him in getting into college, certainly would have been a challenge getting into law school, and ultimately getting admitted to the bar exam. This program gave him an opportunity to change the pathway of his life, and he took advantage of it. And so you as young folks, as you move on in your careers, I hope you can remember things like that, no matter what field that you do. Remember that people may not have the background and experiences that we have when you're dealing with your clients, in criminal cases certainly, and in civil cases as well. And do what you can to help provide them with the tools that they need in order to be successful in their lives. I look forward to the question and answer, and I appreciate the time this morning.
Yes, thank you so much, Honorable Justice Andre Birot. Indeed, each of our speakers brilliantly emphasized one aspect of rule of law, like Sabrina on diversity and Anna Aikens on the role of education and universities like JGU in bringing, educating future lawyers and justices. And now your point about equality of everyone, and most specifically in criminal law, where you need that equality between the arm of the prosecution and the arm of the defense. And that's really what justice is about, the equality not only of the victim but also of the perpetrator, very brilliantly expressed by Honorable Justice Andre Birot. Next in my list, Honorable Justice Sarah Ellis from U.S. District Court of Illinois. It's my pleasure to invite you to the floor.
Good morning, everybody. All right. I have had multiple cups of coffee, so maybe you need a little bit more, but good morning, everybody. All right, good morning. Good morning. My name is Sarah Ellis. I am a judge. I sit in Chicago, and I'm following behind Judge Barat because I'm going to talk to you about reentry court. So he talked to you about the court that they have for people who've been charged with crimes, and they go through that program, and if they finish, then hopefully they don't get a conviction. I deal with people that have already been charged with crimes and are coming out of prison, and we call it reentry court. And the reason that I think it fits in with the rule of law is that it is a program where we are looking at people who have been marginalized, right? These are felons. They're criminals. They are people that society generally says, we don't think about you anymore. You don't belong. And part of the rule of law is justice. It's justice. It is, how do we treat people that society tells us don't have any more rights? That because of decisions you made and things you did, you don't belong anymore. And think about it, right? Each of us have made decisions that we're not proud of. Each of us have made mistakes where you think about, I would go back and do something differently, right? Maybe you said something to a friend where if you thought about it, you probably wouldn't have said that. Maybe there was some money on the ground, and instead of walking past it or picking it up and turning it in, you get overwhelmed by the urge, you pick it up, put it in your pocket, and go on your way. And you didn't get caught, right? And if you thought about it, you know that the right thing to do would have been something different, but you didn't make that choice. And so many people in our criminal justice system don't have the tools that you and I have to make different choices. That they're dealing with substance abuse. They're dealing with, as other judges have talked about, trauma. They are dealing with a lack of education, a lack of opportunity, a lack of family structure. And as a society, what we say to them is, we didn't help you overcome those problems in the beginning. We're holding you accountable for the decisions that you made because of that. And now that you come out of prison, you don't belong anymore. And I think that justice requires practical solutions. So for reentry court, that is a practical solution. So I want you to think about some of the people that are in my court. One of them served 25 years in prison. 25 years. That is probably longer than some of you have been alive. And because of a change in the law, he was told one day, and this was during the pandemic, you are going into a cell by yourself for 14 days to make sure you don't have COVID. And then we're going to open up the cell door and we're going to send you home. Now, of course, home is not where he was 25 years ago. He now has to figure out where he's going to go. And when he got out, things like that computer that sits in your pocket that gives you an answer to everything, he doesn't know how to use that. When you go to apply for a job and you're doing it online, he doesn't have a resume. He doesn't know how to upload his resume with a picture. He doesn't know how to get basic resources that he needs to survive. And so he comes to our court. And this is a person who had spent his young life in gangs, right? And a lot of criminal activity. And when he got to prison, he was pretty angry. And so he would act out. He spent time in solitary confinement. And one day, when he was in solitary confinement, he thought to himself, I have a choice. So I can choose to be magnificent, or I can choose to be miserable. And when he came into our court every week, I would ask him, how are you? And he'd say, I'm magnificent. And I said to him, well, let's really talk about that. Are you magnificent? Let's acknowledge the fact that you just spent 25 years in prison, and that's a traumatizing experience. And you tell us, we are here to serve you. You tell us what you need. Do you need clothes to go to an interview? Do you need us to help you write a resume? Do you need housing, transportation? Do you need therapy because your kids won't talk to you? Because they're still mad because you've been gone for 25 years? Do you need therapy to talk about how you're going to stay sober? How you're going to deal with these challenges? And that is what justice is. That is showing up for people for whom most people don't show up for them. That is caring for people where society says they don't deserve it. That is saying, I love you, to people that don't hear it. So when you talk about the rule of law is only as strong as how you treat the most vulnerable in your society. And I would posit to you that some of the most vulnerable people in society are the ones that didn't get those opportunities. that didn't have those kinds of advantages, and that when society tells us those are the people we should ignore, perhaps those are the people that you should most pay attention to. So a democracy is only going to be as strong as the weakest members of your society. And if you can take care of them, you will take care of democracy. Thank you.
Thank you very much, Honorable Justice Sarah Ellis. You really reminded us how important it is to take care even of the weakest part in our society, and the work you are doing in the reentry court is fabulous. Again, somehow we always think about the grandiose in the Supreme Court, the decisions, the books, and the famosity of some of the cases, but bringing justice to someone who was given justice 25 years ago for a mistake he or she did is really important. So justice doesn't stop with the sentences of the criminal court. It actually is a lifelong experience. Your story really is fabulous. Thank you so much. Next in our list is Honorable Justice Douglas Tukey from Oregon Court of Appeal. Please, your time.
Thanks a lot. I'm really happy to be here. So last night we had the good luck to meet several members of the bar in New Delhi, as well as several judges. And one of the things that they told us was to fasten our seatbelts. And so I think that was in relationship to the trip we had ahead of us. I had never imagined I would have the good luck to visit India. And it's just a real privilege and an honor to be here. I think all of us feel that way. And Dr. Raj Kumar has put together an amazing program. And I think one of the things for me on a personal level as a judge is you have to periodically really sit down and think about and remember what you're doing. When I became a judge in Oregon, I'm from the state court, so I'll give you that perspective. We took an oath to faithfully and impartially discharge the duties of the judge and to respect and safeguard the law. And I think an opportunity like this is just such an honor because it's going to really help me to kind of sit back and think about what we're doing, and hopefully I'll have some lessons learned that I can take back and apply to my job. But one of the things I want to talk about is maybe a different perspective in terms of access to justice is how I think about my job. I'm a public servant. I'm accountable to the people in Oregon to do my best to resolve the cases that come before me. And I think my colleagues, there are 13 judges. To follow up on Justice McKenna, we have a diverse group in Oregon. The majority of the judges are women. There are 8 women and 5 men. We have a range of people from different backgrounds, public defenders, government lawyers. I'm kind of an oddball. I worked in the legislature, drafting laws. There had never been somebody doing that before, but we interpret a lot of statutes. We have 3 people of color, 1 member of a Native American Indian tribe, and 2 members from the LGBTQ community, including me. But in terms of the role of a judge as a public servant, one of the things that the criticisms of my court was that when I started, we have big backlogs. We have probably 2,600 cases approximately filed every year. During the COVID pandemic, there were fewer, but that's increasing. So the goal is to think about, for us as judges, how do we get the cases resolved in a quicker way? So in terms of access to justice, one of the things COVID did that was helpful was that we now have a lot of arguments remotely. I think people were resistant to that when we started, but it's had a real kind of equalizing effect in terms of the arguments, because judges would have to come from Eastern Oregon. I live in the Willamette Valley. It's Portland, Salem, Eugene, the main cities, but there are a lot of other cities throughout Oregon. And so with the remote argument, that was very helpful. just to bring people in. Another thing that's really exciting that I'm happy we're doing, it's that thinking about what's the job, how do we best serve the people in Oregon. We're going to be starting a new program where we allow unrepresented litigants, pro se litigants, to come and argue before our court. As far as I know, there's only one other court in the U.S. that does that. It's in California. So we'll probably start doing that in February. But it's again, in terms of access to justice, having people come, having people feel heard. These are people that don't have lawyers. They don't have the resources to hire lawyers. They're more pro se people arguing in the trial courts, and that's moving up into the Court of Appeals. So that's going to be happening pretty soon. The other issue is just in terms of decisions. When I joined the court, we had the shelf, and people would have like 30, 40 cases sitting on their shelf. And so the judges were trying to figure out, how do we get things done quicker? And especially at the Court of Appeals, we have precedential opinions, so we thought, look, let's focus the longer opinions on precedential opinions. Let's do shorter opinions that are just law correcting and get those out the door. So we've shifted to that, and our backlog is way down. And so again, that's, I think, an example of us remembering our role and remembering what are we doing. We're public servants, and we're trying to get decisions out to people as quickly as we can. But I just also like to say one thing to you all. When I was overseas for a long time, and I came home, and I was trying to kind of figure out what I was going to do. And way back when I became interested in the law, my dad told me to kind of be who you are. And like I said, I don't have a typical background in terms of the judges in our state, but I think I did what I liked, and I was interested in the legislative process. And I think if you do what you like, you'll do well, and you'll do a good job, and you'll have opportunities. And I think the other thing is to maybe piggyback on what Judge Aiken said about, you're already here, you're building relationships, you're building a team, you've got a great opportunity to make connections here, and that's going to help you in the years ahead. So I would just really encourage you all to think about what you'd like to do as a lawyer, and then if you do follow your heart, you'll have good opportunities and do well. So thank you.
Again, thank you so much, Honorable Justice Douglas Tukey. You took us to some of the specificities of the jobs, which are not less important than the more general human nature of justice, how to give everyone the equality of access, how to take care of the speed of the process are extremely important. And obviously, as your final message to our student was that you really need to like the job to do it properly. Those were wonderful words of inspiration to all our students here. Next is Honorable Justice Todd Edins, Judge of the Supreme Court of Hawaii, please.
Aloha. I absolutely cherish my relationship with the Jindal Law School, and I give all the credit in the world to your Vice Chancellor, who is churning out remarkable lawyers. And the reason why I know this is every summer we at the Hawaii Supreme Court are privileged to have some of you students come out and serve as our externs for several weeks during this summer. And I tell you what, the reason why I know you folks are all getting top-notch, world-class legal education is that those externs come out and churn work and pump out and are really good people. And it shows me sort of a holistic aspect to the education you're receiving here. It's not just high-quality legal stuff. It's just putting out really good people who care. And I really, really value that relationship. You know, the legal profession is the first line of defense in the subversion of individual rights. And this is an honorable profession. We have a special role in promoting the rule of law. And I hope that you will use your brain power, your hearts, and what you gather in your years at this institution to go out and do well for your country. The rule of law really doesn't work unless there are people like you folks who are willing to go out there to meet unmet legal needs, to provide access to justice, to ensure that individual rights are protected. And that is absolutely vital to a full functioning democracy. You know, your fellow citizens are going to live happier lives, your lives will be enriched. And I tell you what, your country, like ours, there is a real big void in meeting legal needs. And we have in Hawaii a requirement that all lawyers need to do some public service as part of being lawyers. And in fact, at the law school, that's also a criteria. You have to go out and serve your fellow people who do not have the means to access the courts, the means to address their legal needs. And I hope you folks will fulfill that. Now, one of the topics that I was told to talk about was legal constitutionalism. And what legal constitutionalism really is, it's the role of the courts in interpreting law in the Constitution versus what's known as popular constitution, which I think is somewhat of a fringe idea cooped up in academia, that is really the democratic processes have the role in interpreting the Constitution. What legal constitutionalism does is it's really judicial independence. It's trusting the judiciary to uphold the constitutional principles. It's the role of the courts to protect individual rights. Many countries, your country and our country, that's how we operate, under a legal constitutionalism framework where the courts interpret the Constitution. Other places do not do it that way. They don't have reliable, independent judiciaries that can fulfill that function. You know, I like reading court cases from around the world, and one of the cases that I did read was your Barati versus State versus Kerala case, and that is an absolutely incredible opinion with respect to the rule of law, and the rule of law being in the basic structure of the Indian Constitution. The basic features of the Indian Constitution promote and protect those fundamental rights. And it's for the courts to decide, not the legislative branch, not the executive branch, and that's where the power is. And the other case that I really enjoyed reading was the Golanath versus Punjab case, which sort of preceded the Kerala case. But I tell you what, let me tell you, the United States Supreme Court is starting their new term, started yesterday, in fact. And when you look at the protection of the individual rights, just a year or so ago, the United States Supreme Court erased a constitutional right. It erased the right to bodily integrity. It state-sanctioned forced birth, and that's the Dobbs decision. And that same week, or actually, in fact, the next day, the United States Supreme Court issued a decision called Bruin, and what that did is it basically gutted democratically passed laws to make our communities less safe. Now, for example, people can tote guns in the beautiful beaches that Justice Wilson showed you in Hawaii. That's absolutely an outrageous opinion that is not staying within the judiciary's lane. So when we promote judicial independence, it's very important to remain vigilant about what is truly going on there. We have a Supreme Court in the United States right now that is radical. We have a United States Supreme Court that is engaged in an interpretive modality of constitutional interpretation that is really shrink-wrapping and caging our Constitution to 1791 and 1868. It would be as if your Constitution was fixed and constrained in 1947. The reason why I bring this up is you have to be vigilant. If your Constitution is not allowed to emerge with the times, like apparently ours is now, you might be having a retraction of your rights. So I think that's something that's very important for all of you as you progress in your years as lawyers to ensure that the judiciary doesn't overstep things. We are all here because we love the judiciary. We certainly believe in a legal constitutionalism theory of government. But when you have a judiciary that engages in really what was not more than a few decades ago a really fringe constitutional interpretative model, it really causes harm and destruction to people. And you know, we had, in June of 2022, there was the Dobbs decision, that was the abortion decision, then there was the Bruin decision, that was the decision that allowed people to basically carry around firearms in public. And then also that same week, there was a case called West Virginia versus EPA, where the United States government was trying to do something about climate change. There was regulations regulating greenhouse gas emissions, but what the United States Supreme Court did was it decided this conjured idea about major questions, and it took over that particular executive branch decision-making into its own. So I guess what I'm saying is that, you know, you have to have a democratic society, to have a rule of law society, you have to pay attention. You have to be involved. You have to be engaged. You have to understand what's sort of going on in the various aspects of the legal hierarchy. And again, I've been absolutely amazed at the talent that comes out of this school, and that's really a credit to your professors, to the administration here, and to you folks. So go out and use your skills to better your country. Thank you.
Thank you very much, Honorable Justice Todd Edins, for another excellent message about the role of judiciary in the rule of law as the balance between the three branches and how important it is to have that balance done properly. So it's not only to control the legislative and the executive branch, but also to keep the constitutionality of the balance between the three, and for that matter also never to overcome or overrun the role of judiciary in that balance between the three. We are more than half of the way through, so please be patient. We have 4 more excellent distinguished speakers. Next is Honorable Justice Jenny Riviera, who is coming from the New York State Court of Appeals. Please, Jenny, your time.
Good morning. I'm very impressed the way you can weave everything that's been said seamlessly. I like it. I see why you're here. It's great. Good morning. So I am Puerto Rican and I am bilingual, and we also say buenos dias, buenas mañana, so the same to you. And before I became a judge, I spent almost 20 years as a law professor in legal academia. And I may not know much, but I know a group that looks like it needs to stand up and stretch. So if you would get up, put down the phones, put them away. I've also been watching everybody on the phone. Thank you so much. The ones who are asleep, you can now get up, take a deep breath. Breathe in, breathe out, stretch, move the arms. Feels nice, right? You've been sitting there for a few hours. They're happy to stretch, I can see. See, when I get up and stretch, it makes little noises in my joints. You're all so young, you don't know what that is. Okay, sit down. Great. So I didn't have coffee, so I have to depend on the oxygen and moving around to keep me awake. But it's very good to be here. Thank you so much for the invitation. I'm happy to have a few minutes to talk to you about some of the issues that I think are critical to maintaining, sustaining a vibrant rule of law, a vibrant democracy, one in which we can feel proud and that we can feel that justice is indeed done in our courts. So my new friends and colleagues on the bench have discussed various issues. The topic I'm going to try and cover is one that I hope you will consider of significance to your practice and to your identity as future lawyers, and that is criminal defense and the profession's commitment to being effective counsel for those who have been charged with a crime. You've heard different aspects, I think, of our criminal legal system. So I'm going to talk to you again about our standards of professionalism. So we have a code of professionalism for all lawyers. We have also a code that applies to prosecutors. Government lawyers are held to a slightly different standard, a higher standard in that sense. But beyond the code of professionalism that applies to all lawyers, we also have standards that judges apply to what lawyers do in the courtroom, in the way they represent their clients. So for my purpose, we'll talk about trial lawyers, and we'll talk about appellate lawyers. So you heard I'm on the Court of Appeals. It is our version of the Supreme Court. It is the highest court in New York State. There are 7 members of the court. We hear appeals. We are not trial judges. We don't make evidentiary rulings. We don't listen to witnesses testifying. All we listen to are lawyers arguing cases before us, telling us everything that was done wrong before the case got to us, telling us about how the judge got it wrong, how the prosecutor messed up, how the law is a problem. All of that comes to us, and we have to decide whether or not they've given us a reason to overturn, reverse, hold that there has been an error below, right? So that's what I see all the time when we are in what we call session. Okay. So we have particular standards that as courts, as judges, we apply, as I say, to lawyers. So there's a federal system and there are state systems. My colleagues have already mentioned parts of the federal system and how the state system may have rules, requirements that apply even greater protections to individuals and to communities. And that is so for New York also. Our Constitution is at times read more broadly than our United States federal Constitution. But under the federal system and under the state system, you have a right to the effective assistance of counsel. You're a multilingual society, as is the United States, but you're now learning another language, right? The language of the law. So this is a term of art. Effective assistance of counsel. So when a lawyer fails to provide effective assistance of counsel, the lawyer has been ineffective. That would be a claim that you would bring to my court. You should reverse my conviction because my lawyer was ineffective. Okay. What does it mean to be effective assistance of counsel? For the most part, the federal system, the U.S. Supreme Court, has said that means you comply with the standards of the profession. You provide the kind of representation that our professional standards demand. Nothing less, but that's a minimum. Of course, you could perhaps provide some kind of representation that anyone would say that goes beyond what any lawyer would be expected to provide. Okay. So in New York, that is the same standard, of course, because we're bound by the federal Constitution's requirement regarding the representation of a person who has been charged with a crime. And we also have an additional bit of protection that we provide to criminal defendants. We require meaningful representation, which the best way to describe that means that even if a lawyer might appear to otherwise be more or less providing the professional, the minimum professional standard that is required of them, something has gone wrong in that trial based on what they have either done affirmatively or failed to do, the omission, that has resulted in less than a fair trial. There's something that just is not right about what happened at this trial, and we say we cannot allow a conviction to stand when the individual has not received a fair trial, and that the reason for that falls on the conduct, misconduct, the omission by the lawyer, right? Meaningful representation. These are standards that are very hard to meet. Number one, because we have a professional class of professionally trained lawyers who should know what their obligations are and should be able to meet them, to understand them. So in part, it's because lawyers are doing what they need to do and should be doing. but that doesn't always happen. On occasion, a lawyer falters. It may be negligence, they're not fully prepared, they didn't do the work they needed to do to get up to speed on the case. It may be that they are pressured because of the demands of their practice, and they've slipped and missed something that was crucial, a deadline that was crucial. We had one case where the lawyer, it's very unusual, may I say, for a lawyer to admit they made a mistake for a variety of reasons, not just ego. But this lawyer had failed to timely file an appeal. Now, that meant that the criminal defendant could not seek appellate review of their case. Doesn't mean it would be reversed automatically, just means they would have the opportunity to complain that something had gone wrong below, as I've already described. It's very unusual for a lawyer to admit they made a mistake. They'll usually explain why this happened, or that they didn't do whatever the defendant says they did or didn't do. But this lawyer actually came to my court, stood up, and said, I'm actually the lawyer that this defendant is complaining about. I am representing them here, which is telling you a lot, because why would you continue to hire the lawyer who messed up, right? Very unusual. But he got up to say, I made this mistake. There's no issue in the record about that. You should not hold my client accountable for my error. Give them an opportunity to appeal, not necessarily reverse, but just the opportunity to appeal. But that is very unusual. Most lawyers will not say that they made an error, and many of them have not made an error. Remember, these are just claims. But under our standard of meaningful representations and the standard of effective assistance of counsel, it's very hard to prove that a lawyer has made a mistake, and in the federal system that the lawyer's mistake or conduct, failure to act, resulted in prejudice to you. So they may have made a mistake. As the law stands, as we've said it many times in my court, you're not entitled to a perfect trial. You're entitled to a fair trial. Why do we say that? Humans make errors all the time. The question is, does the error matter at the end of the day? Did it affect the outcome? Did it put you in a worse position than you would have been in but for that error? Can we say we're not really confident in the verdict? We're not sure that it's really based on the facts and the law, but rather based on these errors. Okay, let me quickly, I know my time is running short, tell you about one other case, because this case, as they say, sticks in my craw. That means I cannot let it go, because I feel it is a complete injustice. This case is called People v. Alvarez, the people of the state of New York against the defendant, Mr. Alvarez. So Mr. Alvarez committed a heinous crime as a young person, younger than you. He committed murder. He was part of a gang, drive-by shooting, killed some very young people. At the time that he committed this crime and for which he was found guilty, you could not get a life sentence. But what you could do, which is what the judge did, was give, because he came up on several counts, right? Gave these various sentences for each of those charges, each of those counts, that added up to more than his lifetime, right? More than 99 years. He would never live that long. So basically gave him a life sentence without the law permitting that, but the law allowing for the aggregate of all those years to add up to more time than he would ever be alive incarcerated. But that's not really the problem. The problem here was his appellate lawyer, not the trial lawyer. He was not challenging the trial lawyer when this appeal came to us. He was challenging his appellate lawyer. And what he claimed happened is that the appellate lawyer never talked to him during the process where the appellate lawyer would prepare the briefs to argue that something had gone wrong and that his conviction should be reversed and that he should get another trial. So that was one thing. He also argued that the lawyer almost had his case never heard by any appellate court because the lawyer failed to meet the deadline for submitting briefs to the intermediate appellate court. We're the last court, but the intermediate appellate court. That court reinstated his appeal once the attorney presented the documents. He said, but I almost lost my right to appeal. This was an example for the defendant of the negligence of the lawyer. Third thing he said is, go read the brief that this lawyer wrote. It's horrendous. fourth thing he said is the intermediate appellate court, not my court, but the intermediate appellate court, has the opportunity to review the sentence and reduce the sentence because it's too harsh. That's an argument you make. It's a particular type of jurisdiction that that intermediate court has that no other court has. He said, these are the various errors. I concluded, after I read the brief, which is quite painful to read, because it had errors, no use of facts, no application of the record, no substantive arguments that made any sense, and no citations to support them. I've told you, I've been teaching almost 20 years, and I taught first-year students how to write. I would have failed this person. It was the worst brief I had ever seen. And my measure for this is, would I accept that kind of work for myself if I was a defendant? Would I accept that kind of work for someone I love and care for? And the answer was always no. But these 4 errors to me made it clear that this defendant did not get effective assistance by his appellate lawyer. And that to me meant there is no justice. Now, I wish I could say that I was the majority voice. I was not. The decision was 5-2. Myself and a colleague dissenting, I wrote this particular dissent, setting up in my dissent why there were all these errors, and this could not be what we meant was meaningful representation, because no one would accept a brief that was incoherent. I wish the majority had agreed with me. It did not. So my last point with this is that you have to maintain the highest possible standards for yourself. People's lives depend on it. People's freedom depends on it. And if you would not allow that for yourself, or the person you love most, it's not good enough for your client. So thank you for the opportunity to share my thoughts with you today.
Thank you so much, Jenny Rivera. Thank you for actually taking the extra time to show us this example. Very, very specific and important to know how things can go wrong and why so important are the courts of appeal. Our next speaker is not a judge, but an excellent academic, the very dear friend, the Dean of the Hawaii Bill Richardson School of Law, Camille Nelson, please.
Thank you very much. Good morning, everyone. Okay, I have a question for you. First of all, you've all been tremendously patient, and I want to hear from you. Why did you go to law school? You're all in law school, right? I want to make sure we know what you're studying. You're all law students, yes? I want to hear from 5 people. Just shout it out. One sentence. Why did you come to law school? Good answer. A+. To do what? Criminal law. Why? Okay, fun, interesting criminal law. What else? Last point. Then the woman behind you. I want to hear one more thing. Why fun and interesting? Because my father doing it. Okay, it's good to listen to your parents. Lawyers are institutions within themselves. Okay, very good, very good. Yes? To become a judge. Why? Power and respect. Okay, very helpful. Okay, yes. Indeed. Okay, so great deal of power and responsibility on the shoulders, and things are going in a direction that you don't necessarily think is ideal, which is weakening the institution of justice. Yes. Corporate law. Okay, behind you, was there a hand? Anyone else? Yes. You're bad at math. But you're good with words. Exactly. Okay. Anybody else? Yes. The law demands a certain sense of nobility. Well said. Did I miss a hand? Did I miss anybody? Are you volunteering your friends? No? Okay. Well, I appreciate your feedback. It's really important for us to hear from you.
because it's really important who you are. And for those of you who didn't volunteer an answer, think to yourself in your heart, why are you doing this? And do you think it'll make a difference? Either for you, for your family, for society, for your community, for the country, for the world. Do you think this can actually make a difference? Or is it a waste of your time and perhaps the time of your families, your communities, your country, et cetera, et cetera? Someone is investing in you. You are investing in yourselves. There is a reason why, as malevolent as the rationale is, enslaved people were not allowed to learn. They were not allowed to learn to read. They were not allowed to learn to write. They never had the opportunity to be bad at math and good with words, because your education and your ability to acquire knowledge, which will ultimately translate into wisdom, is powerful. It is potentially transformative, not just for you, but for your families, your communities, your people, your community, your country, and the world. So let me just tell you a little bit about what I've learned over the last 20 plus years teaching at a dozen law schools and being dean at 3. Okay, so this is what I'm hearing from students that I've taught in the UK, Canada, and the US, and also France. All right, they are coming to school so they can have a greater societal voice and impact in whatever space. So corporate law, sports and entertainment, criminal justice, whatever it is, fill in the blank. Some of the areas that I have heard from our students in those several continents and country include healthcare disparities. For example, the post-pandemic realities. I think we've learned a lot from the pandemic in terms of who survived and who didn't, the challenges. And certainly in America, there is increasing concern with political polarization and the binary that is American politics, certainly made abundantly clear by the fact we only really have 2 parties, which in many countries is not the case. There are often more than 2 political parties. We have heard from students that they're very concerned about national and international racial reckonings. Perhaps that resonates here in India after the murder that you probably saw of George Floyd, if not many others. I've lost count of the people who we've seen murdered on these devices, let alone the trauma of seeing actually people assassinated over and over, or executed or murdered, right? That's a whole other conversation that we need to have in terms of the young people seeing and witnessing that type of violence quite easily all over the world, and the toll that takes on us, which brings another point of departure for what students are telling us. They care increasingly about mind, body, spiritual integration and teaching to the holistic self. So we're not just a physical entity. Doesn't matter that we're able or well. Doesn't matter that we're tired or we're sick. Doesn't matter about our various states of wellness. I think it should, and it does. Students are very concerned about affirmative action and diversity, inclusion, and equity, or the lack thereof. Students are very concerned about anti-LGBT policies. Certainly in the States, we've seen the proliferation of policies around don't say gay and transgender bans. Students are increasingly concerned about the prohibiting of reproductive rights in a post-Roe, post-abortion world. Certainly students are very concerned about indigeneity and the rights of First Peoples the world over, and students are very concerned about internationality. The fact of the matter is, when you study law, it is interdisciplinary. Law exists in a political, economic, social, and historic space. You cannot abstract law separate and apart from the dysfunction that is often our political, economic, political, societal space. It is not in a void, nor is it in a historical void. And because I'm Canadian, I have to cite to Bob Marley. Who knows Bob Marley? Internationality, right? Internationality. So the motto of Jamaica is out of many, one people. And certainly those of you who know your history know there's a profound connection because of enslavement and servitude between Jamaica and India, right? If you know your history, you know that. And so Bob Marley in Buffalo Soldier said, if you know your history, do you know the rest of this? Then you would know where you're coming from. then no one will ever have to ask you, who the heck do you think you are? Because you're a Buffalo soldier, right? Dreadlock Rasta. The point is, history is connected to the present. Everything is connected to the law. History is connected to the law. So I encourage you to be you in the law. I didn't get to ask you who you are and where you come from and why you're here, truly in your hearts. But I would encourage you to not forget the answer that you said to yourself when I asked you, why are you here? Why are you studying? Because that is empowering and potentially transformative. Whether you know and are good at math or not, you can make a difference because of who you are and of what heartbeat is keeping you going in these studies that I know is exhausting and it makes your days long. So don't forget that ever.
Thank you, Camille, so much for these excellent words of inspiration. I'm sure students will follow that. And in fact, you see the fact that our multidisciplinarity in GU is also very part of the education here. And that makes probably the best lawyers when they study within the context of economics, politics, history, and everything else. Michael Wilson already said it all this morning. He doesn't want to come back to the podium. So we have a final speaker, which is Honorable Justice Josephine Staten, the judge from Central District of California. And please be ready with your questions, which will follow immediately after this final opening remarks, please.
Good morning. I think it's still morning, is it? All right, it's been a bit long for you, but of course I have to follow the passionate, charismatic law school dean. And so I feared that my words would not be enough to keep you awake as the last speaker of the morning. And which button do I press? All right, so we're going to, I love that you are embracing these very weighty topics. And so I wanted to dive right into the weighty topic of how the courts can protect democracy. But I wanted to start with what it is we're protecting, what it is we value so much about democracy. Historically, democracy has always been a bulwark against the deprivation of human rights. And the United States fought a revolutionary war against a certain colonial power, we will say, in order to secure those rights. We then had to fight a civil war to bring meaning to the words of our Declaration of Independence that all men are created equal, but you will notice it says all men are created equal, and it wasn't until the 20th century that every American had the right to vote. And I'm not going to say we're given the right to vote, but took the right to vote. And so yes, democracy means free and fair elections. It means voting, but as Aaron Barak, who is a former Israeli Supreme Court justice, once said, democracy is not only representation, democracy is also basic values, the center of which are human rights. And he said democracy is a delicate balance between majority rule and individual rights. But what I think we may have forgotten is that democracy as a form of government is both fragile and uncommon. And while democracy may be fragile, it can't be bubble wrapped and placed on a shelf, right? Democracy is a living thing, and the world is a rough and tumble place. A place where some people may even violently disagree about what matters most in democracy, like the peaceful transfer of power. I'm hoping that's an image, well, unfortunately, it's probably an image that you recognize from the United States. So, what is the role of the courts in upholding democracy? I have like 3 minutes here to talk to you, so I'm going to address 3 threats to democracy where I think the courts can play a central role. The first threat is a slide into autocracy. In an autocracy, separation of powers, and I'm not sure if you can see that, but that's countries experiencing autocratizing events in red and democratizing events in blue. And so it's a bit of a scary period. In an autocracy, separation of powers is lost, and the courts are not independent. They are used by political leaders for consolidation of power and for social control. Right? They are not real in the sense that we know them. A recent study by 2 U.S. Political science professors examined 163 countries in troubled times. By troubled times, I mean threats of, economic threats, threats of terrorism, threats from other countries, and determined that nations with independent judiciaries were more likely to remain democracies in these troubled times. So but they only maintain their independence if they are perceived by the public as being independent. That's one sort of underlying criterion. So we as judges have to maintain both the perception and the reality that we are independent. And I think we can do that in 2 very public ways. First, by avoiding any perception of corruption, by following strict codes of conduct and financial disclosures. Now, my colleagues from the US, and I'm not going to go into it now because I don't have time, might see some irony in the photos that I've put up there for a particular reason, and maybe we'll discuss that a little bit later. But second, it's by issuing decisions that respect the rule of law, and I'll get to that in just a moment. The second threat that democracy needs to be protected from is populism. Populism presents as democracy. That's what makes it so insidious. It purports to be the will of the people, standing against the corrupt and elite institutions, right? And populists often paint the court as an institution that is elite and thwarting the will of the people. But our democracies are constitutional democracies. They are intended to resist the tyranny of the majority. As I said earlier, judges are obligated to strike a delicate balance between majority rule and individual rights, between national identity and fundamental freedoms. And I wouldn't be a judge if I didn't quickly discuss at least one case, and I will leave it at that. 80 years ago, a state legislature had ordered all school children, regardless of their religion or their personal beliefs, to salute and pledge allegiance to the flag of the United States, upon pain of expulsion from school, and our Supreme Court struck that down as violative of the constitutional right to the freedom of expression. The language of the Supreme Court was bold. It pulled no punches. The court said, "Those who begin coercive elimination of dissent soon find themselves exterminating the dissenters." Remember, this was 1943. That decision was not without controversy. You heard Justice Frankfurter mentioned earlier. He was a dissenting justice in that case and argued that legislatures were the very embodiment of democracy. Judges are not super legislatures, and the court was not exercising proper judicial restraint. So proper judicial restraint brings me to my last and final threat and my last point. Democracy also needs to be protected from judicial imperialism. As unelected judicial officers with the power to reject state and federal laws as unconstitutional, the courts could easily slide into illegitimacy by appearing to decide cases based on our own policy preferences. As one contemporary constitutional scholar, this is Mark Lemley, once said, right now in the US, the danger is mostly apparent in the dismantling of political institutions and the withdrawing of individual rights, because the conservative majority has targeted those things. But even conservatives should be worried about an imperial Supreme Court, which in the future might just as easily swing in the other direction. So when I said earlier that we have to maintain our legitimacy by respecting the rule of law, I meant that the court should not be swinging in any direction. To preserve our effective role in democracy, we have to be conscious of our limited role, so that on those occasions where we do step up and we say, let me move past that, where we do step up and we say, this right is fundamental. It may not be submitted to a vote. It does not depend on the outcome of any election. When we do step up and say that in significant cases, we want that decision to carry the day. Thank you.
Yes, thank you so much, Josephine. And we understand the display of the map of the world with the colors was specifically important to see where we stand today. Unfortunately, only a few days back, we had yet another populist coming to power in Slovakia. So the tendency is there, and your alarm bell is absolutely powerful here. And the role of the judges here to correct the mistakes of whoever might make mistakes. Those could be kings or emperors or even, as we see, elected officials. Thank you. Now, question time. We have given about 25 minutes for that. We need to finish at 12 because our distinguished guests need to be taken to their next event. So please, can I just see students? Yeah, just raise all your hands who want to ask questions. I see quite many. So therefore, what we will do, we have microphones that will come to you. So I will ask our speakers to listen to several questions and to indicate or even come to the floor, whoever wants to come to the floor and answer some of those. So we will start from left to right. I saw 5 or 6 hands already on that row. So shall we go one by one? Pass the microphone, be brief, just ask your question and pass the microphone to the next student. Thank you.
Hello. I wanted to, first of all, thank you for speaking and imparting your wisdom on us on this morning, especially because most of us didn't know we were coming into this event. It was quite impromptu. But anyways, moving on to my question, I wanted to ask, given that law runs parallel to how society works and it grows with how its people change over the course of time, do you think it's at all rational to concretize what the law means, given that it might change in the next 10 years itself? So what do you think is the rationale behind saying that this is absolute and this must be followed, when you know that in 10, 15 years itself, when we grow, the younger generation might come up with something new and some other idea or lifestyle?
Thank you. An excellent question about continuity and change. We always struggle with that. We know the law usually is conservative, but in time of turbulent changes, what does it mean? What will be the law in 10 years? From United States to us. Thank you all for the time spent with our students. I'm sure they appreciate that. We will have more opportunities. It was, I chaired many panels in my life, but this was really the most distinguished panel I ever be able to moderate. So our pleasure to have you in Jindal. Please welcome back anytime itinerary coincides with that, we will be always very, very pleased to welcome you in Jindal University. Thank you once again. Thank you, students, for coming and for the excellent questions you have. Back to the office, I finished.